Hi guys, I am Rakshana Begum. Today I will discuss with you Directive Principles of State Policy, Indian Polity, part 2. Let's start. If you want to see it the Bengali version, I will give it to you in the description box. What are the Directive Principles of State Policies added by the 42nd Amendment Act 1976? 42nd Amendment Act 1976 added 4 new directive principles in the list. Number 1. Article 39 to secure opportunities for the healthy development of children. Number 2. Article 39A to promote equal justice and to provide free legal aid to the poor. Number 3, Article 43A to take steps to secure the participation of workers in the management of industries. Number 4, Article 48A to protect and improve the environment and to safeguard forest and wildlife. Facts about Directive Principles of State Policy. Number 1. A new DPSP under Article 38 was added by the 44th Amendment Act of 1978, which requires the state to minimize inequalities in income, status, facilities, and opportunities. Number 2. The 86th Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21A. The amended directive requires the state to provide early childhood care and education for all children until they complete the age of 14 years. Number 3. A new DPSP under Article 43B was added by the 97th Amendment Act of 2011 relating to cooperative societies. It requires the state to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Number 4. The Indian Constitution under Article 37 makes it clear that DPSPs are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Criticism of Directive Principles of State Policy. As a point of debate, the following reasons are stated for the criticism of Directive Principles of State Policy. Number 1, it has no legal force. Number 2, it is illogically arranged. Number 3, it is conservative in nature. Number 4, it may produce constitutional conflict between center and state. What is the conflict between directive principles of state policy and fundamental rights? With the help of 4 court cases given below, candidates can understand the relationship between fundamental rights and directive principles of state policy. Champakam Doraraijan case 1951, Supreme Court ruled that in any case of conflict between fundamental rights and DPSPs, the provisions of the former would prevail. DPSPs were regarded to run as a subsidiary to fundamental rights. Supreme Court also ruled that Parliament can amend fundamental rights though Constitutional Amendment Act to implement DPSPs. Result: Parliament made the First Amendment Act 1951, the Fourth Amendment Act 1955, and the 17th Amendment Act 1964 to implement some of the directives. Goloknath case 1967, Supreme Court ruled that Parliament cannot amend fundamental rights to implement directive principles of state policy. Result: Parliament enacted the 24th Amendment Act 1971 and 25th Amendment Act 1971, declaring that it has the power to abrogate or take away any of the fundamental rights by enacting constitutional amendment acts. 25th Amendment Act inserted a new Article 31C containing two provisions: no law which seeks to implement the socialistic directive principles specified in Article and bracketing C23 shall be void on the ground of contravention of the fundamental rights conferred by Article 14 bracketing equality before law and equal protection of laws, Article 19 bracketing protection of six rights in respect of speech, assembly, movement, etc., or Article 31 bracketing right to property. No law containing a declaration for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. Kesavananda Bharti case 1973. Supreme Court ruled out the second provision of Article 31C added by the 25th Amendment Act during Goloknath case of 1967. It termed the provision unconstitutional. However, it held the first provision of Article 31C constitutional and valid. Result: though the 42nd Amendment Act, Parliament extended the scope of the first provision of Article 31C. It accorded the position of legal primacy and supremacy to the directive principles offered the fundamental rights conferred by Article 14, 19, and 31. Minerva Mills case 1980. Supreme Court held the extension of Article 31C made by the 42nd Amendment Act unconstitutional and invalid. It made DPSP subordinate to fundamental rights. Supreme Court also held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. Supreme Court's ruling following the case were: Number 1. Fundamental rights and DPSPs constitute the core of the commitment to social revolution. Number 2. The harmony and balance between fundamental rights and directive principles of state policy is an essential feature of the basic structure of the Constitution. Number 3. The goals set out by the directive principles have to be achieved without the abrogation of the means provided by the fundamental rights. Conclusion. Today, fundamental rights enjoy supremacy over the directive principles, yet directive principles can be implemented. The Parliament amended the fundamental rights for implementing the directive principles so long as the amendment does not damage or destroy the basic structure of the Constitution. Please like, share and subscribe on my YouTube channel. Thank you.